First of all, it's just been so wonderful to hear everybody talking about this issue, and I want to thank Andrea and Christopher, for what you've been doing. I don't know where he is. And Dean Mendel, and for making this happen, and Alice for all the work she's done on this. It's just extraordinary. And I think what is really incredible, and I have been privileged to have this over the years, is the interaction between my office and the academic field. And Pasquale and I were talking the other day about how people often say, well, that's just a proposal from academia, as if that's a problem. And what I have found, and I think that this conference shows how important to people's lives work on this level is. And I treasure these interactions. Now, I have to say, I treasure the interactions that I have when I go out and talk to taxpayers. As Jung Kyung said, just having that immediacy and the urgency of their issues, and then being able to take those issues and think about it at a higher level, at a level of theory or principles and orderliness. Somewhere I think in there that the advocate offices are in between. They're taking theory and putting it into practice, and they're taking practice and raising questions to theory. And that marriage is really, that might be one thing where tax is actually exceptional in a positive way. So what I thought I would do, since I didn't have any remarks this morning, but now by midday I now do because I listened to you all, I thought I would really talk about the path that the Taxpayer Bill of Rights in the United States took. And I will tell you some inside stories. Again, I am an IRS employee, but under no circumstances do I represent the views of the IRS, the Department of Treasury, or anyone other than myself, who, as I say, happens also to be the National Taxpayer Advocate. So I'm pretty confident I represent her views. So the first thing is, in a rights analysis, you take your taxpayers as you find them. I have my local taxpayer advocate from Philadelphia here and some folks from my office, and they have all heard me say this. We are not judgmental, even with people who have done incredibly stupid things or even illegal things. You take your taxpayers as you find them, not how you want them to be. And that is your starting point with taxpayer rights. I will tell you that we learned, somebody raised this to me the other day, that there is an episode of Criminal Minds, the TV show, where one of our case advocates, this is all fiction, received a lovely little box. This is interesting, this week, in fact, and it came to the office, and I'm not sure how it got through our mail processing, but as she opened it, it was a dismembered arm. And, we got the FBI in, and the local taxpayer advocate got involved. And I'm amazed that Criminal Minds knew the local taxpayer advocate, the case advocate, connection. And over the course of it, of the episode, they discovered that it was a serial killer who TAS had helped at some point. And with a tax problem, the case advocate had helped him out, and he sent her that along with several other little boxes to people who had helped him in the past in his life as thank you notes. So again, we take our taxpayers as we find them. And that also goes to Facebook, because sometimes people talk to me about, taxpayer rights being only available to taxpayers who don't have representation or the vulnerable populations. And I am an equal opportunity advocate. I do not care whether you are fabulously wealthy. I do not care whether you are fabulously poor. I care about your rights, period. That's it. I care about how the IRS as a tax agency is treating you. And that is the beginning of all taxpayer rights analyses. The origin of my thinking on taxpayer rights, since it really, it came from my life representing taxpayers and seeing what the IRS with its awesome powers could do, really started with my research into what OECD had done in the 90s, the late 90s and early 2000s, where they had done a survey of their member countries. And you can see this online, and we cite it in all our materials, about what were their taxpayer charters, were their bills of rights, what exactly was there out there among their member countries. And they did a practice note which recommended 10 rights and 5 obligations for taxpayers. And so in 2007, in the annual report to Congress, I basically, after having been in the IRS for 6 years, thought, we need this. And at that time, I recommended, that Congress adopt the 10 rights and the 5 obligations. And the obligations were, the obligation to be honest, the obligation to be courteous, the obligation to file and pay timely, blah, blah, blah. Sort of as a reciprocity, not a reciprocity, but that there are rights, but there are also obligations under the code. And at that time, I said, really what we need is an organizing principle. And my thinking about this, which carried on into 2011 and then again into 2013 annual reports, is that there are actually tremendous number of statutory rights that protect taxpayers. We have had 3 taxpayer Bill of Rights between 1988 and 1998 that put a lot of protections in the Internal Revenue Code. And out of those came a lot of administrative protections as well. But taxpayers don't know them. And so if they don't know them, how will they avail themselves of their rights? And my thinking was we need some principle-based language in which, taxpayers can at least say, wait, don't I have this right? And then you can get into the conversation about whether there's a specific statutory provision or an administrative protection, or maybe there isn't. And so maybe we should do something about that because we don't like that. And that sort of led, so in that's how I got into it. That recommendation landed with a big thud. And then in 2011, because, I like to tilt at windmills, I reiterated that. And by that time, we had done a survey of U.S. taxpayers. So it was a representative sample of U.S. taxpayers. And we do our surveys by phone because Pew Research has shown that online surveys are biased against African American and Hispanic individuals. And that those populations matter to me. So, we do phone surveys and we do them mobile because so many people have smartphones at this point. But the idea is to get people on the phone and talk to them. And what we found in this nationwide survey was that 11%, just 11% in 2011, 2012 of US taxpayers believed they had rights before the IRS. By the way, our survey was of taxpayers who actually had filed in the last 3 years, so they weren't people who didn't have interaction with the United States. More so, of that 11%, only 54% knew or thought they knew what those rights were. And so we used that data point in between 2011 and 2013 to make the recommendation. I got tired of telling Congress that they should go ahead and enact the Taxpayer Bill of Rights. I sort of thought, well, the IRS could adopt it itself. And we used that data point to be sort of convincing. But, and also about that time, I can't remember if it was 2007 or 2011, I also recommended apology payments. This was something that I picked up from UK, and Australia does it a little bit, which is that if the IRS has done something that torments the taxpayer, you sort of can give them a payment that says, we're sorry. It's not meant to be compensation, but it is symbolic. And I recommended that the IRS be granted the authority to give apology payments up to about $1,000. And this sort of went to the right to quality service, which of all the rights is the most difficult to say, how do I have a remedy to this? And so at least you would get some symbolic recognition that we had, the IRS had really goofed and driven you crazy. There was actually a person who wrote a blog who said, in response to the apology payments, Nina Olson is a lovely and very intelligent person, but this is a non-starter. And I thought, I think thank you for that. I just, that was a very strange comment. Okay. Okay, but something happened between 2011 and 2013 when we published our 2013 annual report to Congress, and that was a little thing you might have heard of, namely the Tea Party IRS 501c4 debacle, where the IRS had to be on the lookout list for names that related to Tea Party, freedom, also, 99% or 1%. So it was going in both directions, but that got a lot of attention, led to the resignation of an acting commissioner, led to the resignation of the commissioner of tax-exempt government entities, oversight hearings, multiple investigations. And so in the summer of 2013, the House, on a bipartisan vote, passed the Taxpayer Bill of Rights, passed the predecessor to what is now 7803A. So by the time you get to 2015, the House has already passed it once. And it was a bipartisan vote. So we get to 2013 annual report, and I'm like, why wait for Congress? They've already tried it, hasn't picked up traction. The IRS could adopt it. November 2013, before my annual report came out, we had a new commissioner brought in to sort of temporarily clean, try to clean up sort of the EO mess. 2014, the commissioner privately agrees with me that we should do the TBOR, and the work on the TBOR begins internally. June 10th, 2014, the IRS adopts it and then immediately starts explaining it away. June 10th, 2014, I send a message to my employees saying we can do a little happy dance right now, but now the real work begins. This is now when the real work begins. And so where I sort of am at that point in 2014 is the camel's nose is in the tent. We now have the IRS adopting this. December 2015, Congress adopts it in 7803A3, and you all, we've talked a lot about it this morning. So by that point, the camel's shoulder is in the tent. And the rest of what we're going to do is how do we get the rest of the camel's body in the tent? Although why we would want the camel in the tent, I don't know. But that's a saying, and I'm going to work with it. Okay, so I thought I would talk a minute about negotiations to get this thing public. First thing I want you all to note is that this document that really constitutes the Taxpayer Bill of Rights as of June 10th, 2014, was publication 1, which is mandated by law to be delivered to taxpayers at various points in the dispute resolution process. And so the language, the negotiated language that we came up with, that you've got in your, the thing that Taxpayer Advocate Services posted as this in 2 languages, because we actually looked at various script that came from a few buildings right around the corner here, Independence Hall and wherever, is that, it got put into an actually statutorily mandated document. So as we're talking about what the legal significance of this is, we might want to think about that this is based on, this language is the notification that is required by law. Okay, so that has some legal significance in and of itself. The other thing I would suggest to you is that you pay very careful attention at the negotiated language that's in publication 1 or done in this document. That language started in my descriptions in 2007, 11, and 13, and then became negotiated. And if someone could do a really interesting track change to look at where I started with my descriptions in the annual report and where we ended up. And I'm going to talk about a few of those negotiations right now, and one of these days I'll write an article about it because I have all the paperwork in red line. For example, the much paid attention to right to an appeals. The right to appeal an IRS decision in an independent forum. That's the heading. If you look inside it, I specifically made sure that it spoke about the Office of Appeals as well as the court, because Congress in 1998 told the IRS by law to establish an independent Office of Appeals. That is that right to an independent forum. I was trying to make the point that appeals is an independent forum before court, but it is an independent forum. I also pointed out, we also negotiated, and this was heavily, that I got in with no negotiation, the word generally, because the IRS unit says taxpayers generally have the right to take their cases to court. The IRS was very worried anytime we said taxpayers have the right to take their cases to court. People would come in and say, well, I've got my right to take my case to court. Why can't I? So it's like, okay, generally. And then we talked about penalties. One red line version I have, it says, are entitled to a fair and impartial administrative appeal of most IRS decisions, including many penalties. I had including penalties. The IRS struck that entire clause out, and then we negotiated that it would say including many penalties, because I told them that was a non-starter, that I had to see the language penalties in this. One of the ways I was able to do that was that during 2012 and 2013, the Taxpayer Advocate Service conducted about 32 to 36 focus groups around the United States with taxpayers and preparers and practitioners sharing the language that we had developed for the Taxpayer Bill of Rights. And people kept raising the question about what about penalties? Do I have the right to appeal penalties? And so I used that to say to the IRS, if this is about taxpayers, this is a question. Look at this report of the focus groups. They are asking about that. So we have to have the word penalties in there. Then we had a lovely discussion about privacy, the right to privacy. It was very important to me to get into the right of privacy, that taxpayers have the right to expect that any IRS inquiry, examination, or enforcement action will comply with the law and be no more intrusive than necessary. One version the IRS sent back to me struck that language, no more intrusive than necessary. And I said to them, so you're unwilling to put the language that is a direct quote from Internal Revenue Code 6320/30 in this collection due process. Could you say that in the microphone, please? So that language came back in, and now, of course, what the right to privacy has done is expanded it to any IRS inquiry, brought the balancing test from collection due process outside of collection due process and into exam, appeals, anything, taxpayers' accounts, any inquiry, no more intrusive than necessary. And then we had a lovely discussion about the right to retain representation. You will note that it says you've got the right to retain representation. You don't have the right to representation. And that goes, we still have lots of work to do to bring civil issues up with criminal, issues so that there's a right to representation there. But we had a little discussion about the reference in there that says taxpayers have the right to seek assistance from a low-income taxpayer clinic if they cannot afford representation. And one version eliminated that language entirely. Well, I think anybody who knows my background will understand that that is also a non-starter, and I would go public on that one very, very quickly. We finally were able to negotiate that they don't have the right to representation from a low-income taxpayer clinic. And I thought, well, I can live with that because the clinics need to have the ability to say, my workload, I can't take this case in right now, and also decline representation, just like any attorney has the right to, or has the right to do. So we got the language of right to retain, the right to seek assistance, so that if a taxpayer says, wait, I want to go to a low-income taxpayer clinic, then you know what, the IRS, you have to stop while that person tries to go see a low-income taxpayer clinic. Just stop. And so that's just an example of some of the back and forth that we had with this negotiated language. Now, I want to share with you about the taxpayer obligations, because remember that I recommended, rights and obligations. And the IRS decided that, first of all, in the focus groups, the taxpayers said, this is insulting to us. We already know that we have the obligation to be honest. And I'm like, oh, really? But anyway, they said that was insulting. The preparers and practitioners said, that's insulting. We know all this stuff. The commissioner said, we don't want to do that, which sort of tells you a little bit about why the IRS was so willing to do this right now. Don't forget that the EO debacle was working its way through. So some of this was, they thought this was a good news story that might bump some of the bad news stories out of the press. And that was why, if they did the obligations, somebody might say, here's the IRS beating up on people again. So they just adopted the taxpayer rights. I continue to believe it's very important to state obligations of taxpayers. I am a little, one thing that I'm nervous about is that there were people in the IRS talking about, it's a quid pro quo. If you do not, follow all your obligations, you have no rights. And I do not believe that at all. They are independent, and so otherwise the rights mean nothing because people are constantly not obeying the law and making mistakes and things like that. And if you forfeited your rights in that context, you wouldn't have any rights at all. All right, so then we get to post-IRS adoption, pre-codification. So we did some training of my employees on how to use taxpayer assistance, how to use the TBOR in taxpayer assistance orders. And my employees started issuing taxpayer assistance orders saying, this violates the Taxpayer Bill of Rights. And someone in the IRS ran down the hall to the commissioner's office and said to him, Nina and her people are saying it violates the Taxpayer Bill of Rights, but Nina has been saying all along this TBOR doesn't create new rights per se, so how can it be a violation? So the commissioner talked to me and I said, you know what, you're right. It's not a violation of law because the TBOR isn't a law. So we went back to the thesaurus and we sent out guidance to our employees saying, you can use impede, you can use impair, you can use undermine. We gave them a whole bunch of words that they could use. And then post-codification, it's now the law. So we sent out other guidance to our employees saying, now you can say violate. It's a law now. So we did that. So now people are saying this violates the right to retain representation. This violates the right to privacy. Now, I want to make a distinction between TBOR as an IRS policy and TBOR as the law. Where else do the words taxpayer rights show up in the Internal Revenue Code? I'll tell you the answer. Nowhere. Nowhere. They don't exist in the IRC, that phrase. So despite 3 pieces of legislation entitled Taxpayer Bill of Rights between 1988 and 1998, there was never in the Internal Revenue Code a mention of the 2 words taxpayer rights. All right? So that means that those words mean something in 7803A3. It has significance. I don't know what that significance is. That's partly your job. As part of the 2011 annual report to Congress and how we got the IRS buy-in, we said that the Taxpayer Bill of Rights were organizing principles, and I talked about the taxpayer ignorance, that if you don't know your rights, how will you claim them? So my thinking was that just like everybody in the United States knows that they have the right to free speech, if you tell somebody they can't say that, your 3-year-old or your 5-year-old will say, I have the right to free speech. And then you say, no, you don't, I'm your parent. No. But everyone says that, they know that. And by saying that, don't I have the right to free speech, you begin a conversation. So you can say, well, the example that I've used is, you don't have the right to cry out fire when there is no fire in a crowded movie theater. You don't have that right. That free speech doesn't go that far. You can burn a flag, but you can't cry fake fire in a crowded movie theater. So they're boundaries to even the most fundamental rights. And that's what we thought, if we could have these organizing principles, we could organize underneath them the existing statutory and administrative protections that relate to and give meaning and often enforceability to those rights. And there was a reference to the crosswalk that we did. It's on our taxpayeradvocate.irs.gov website, which is a crosswalk of all of the provisions that we could find that relate to each of the 10 rights with plain language explanations, all of which has been approved by the IRS Chief Counsel so that we are legally accurate in what we say. One of the things that did is it showed where there are gaps. And what I've been doing since 2013 is really focusing on making legislative recommendations to fill some of those gaps where we have not got actual express remedies, forget about implied, but express remedies for particular provisions. So I want to talk a minute about the right to appeal. Like, what does that mean? Well, to me, what's important about the Facebook case is what led up to Facebook being in that position. For decades, it is like I said, in 1998, Congress told the IRS in RA 98 that you establish an independent office of appeals. They felt so worried about appeals independence that they wrote that in the bill, okay, in the act. Now, up until a little bit ago, a couple years ago, 1 year ago, there is a procedure that has been around for determining whether cases will be allowed to go to appeals or will only be litigated. And that is called designating a case for litigation. That is a very specific procedure. It's laid out in public procedures, and it requires appeals, this independent office of appeals, and counsel to agree, okay? They have a procedure. What happened to Facebook and other taxpayers and in Facebook was that because it is a procedure with many steps, counsel didn't like that. So they created something called, we'll deny you appeals on the basis of sound tax administration principles. Like, what? What's that? Did you put that out for notice and comment? Who gets to make up what's sound tax administration? Oh, you unilaterally get to call the shots, which is what they did. They didn't ask appeals. Appeals has no role in this. Counsel gets to say to this independent office of appeals, you don't get to see this case because we've decided it's in the best interest, of sound tax administration. That I have problems with. You're not willing to go through the steps. And in fact, the IRS told the Ways and Means Committee when they asked about this, like, why are you doing this? Because people were squawking. They said, well, it's just too difficult to get things designated solely for litigation. Well, I'm sorry, but that's just not a good enough reason. And so what we've lost in this whole discussion about Facebook is why they were there in the first place. And that was a violation of the taxpayer's right to an independent appeal. That end run around a published existing protection for designating a case for litigation, which had all sorts of parts of the process and steps in the process. And instead just a because I said so. And anytime somebody says to me because I said so, I just have a real problem with it. That's going to lead, by the way, in my annual report to Congress, because we are trying to plug gaps, to a right to appeal, a legislative recommendation discussing a right to appeal. Okay, so then the other little piece of advice I would have to say to you is to look to the order of the rights. In this document, I was very careful with that order, and the IRS did not change it. And I really thought through how a taxpayer interacts with the government and where these rights might accrue. And I think that's very important as you're doing an analysis, like whether it's in a case or in an issue or anything like that. And think about the number one right, the right to be informed. Now, that to me is all about transparency. It's all about guidance. It's everything Kristen was talking about this morning. It is the number one right. You don't even get into tax administration. You don't get anywhere unless you know what you're supposed to do. What does the government expect of you? That is fundamental, and the government has an obligation to tell you. No more secret law. Now, what was interesting with that, and I just want to give you a little detour. I did a C-SPAN program. I do C-SPAN every year on Washington Journal, and now they've got me on for an hour where I just take calls from everybody and anybody who wants to talk about anything about tax, which is really fun. But this year I got calls from all sorts of people asking about the new tax law, and they weren't asking about the changes. They were asking about what hadn't changed. Had the standard deduction for the blind and elderly changed? Had the, safe harbor for small business, the standard deduction sort of for having a business in your home, had that changed? Had the taxation of Social Security changed? And I thought, I haven't been focusing on that. I don't know, I don't know. So as I walked back with my staff from C-SPAN to the IRS headquarters, I said, it would be really great if we could create some kind of chart or something that would show not only what had changed, but what has changed. And my brilliant staff, my brilliant director of communications, said, we should create a 1040 where taxpayers could click on each line And people could then see, oh, this is what I claimed last year. It's disappeared for next year. So that was at end of February, and by June 30th, my people had created precisely that. And if you go to our website and our tax reform site, you will see that. What you will see next week is a Spanish version of that entire site. Next, there is no IRS 1040 in Spanish. There is no official 1040 in Spanish. My people just created it. Next week, you will see for the first time ever a 1040 in Spanish. It's not an official publication, but I've been talking to the IRS Forms and Pubs people saying we did all our work. We actually had one of my intake advocates from Puerto Rico detailed into that office, and she did the translation. Bless her heart. And so this is about the right to be informed. This is core right to be informed. All right, right to quality service. This imposes an obligation on Congress, partly, to fund the IRS so it can deliver that service. It's not just operating in a vacuum. We can say the taxpayers have the right to quality service, but we don't have enough employees to answer the phone calls that we're getting in, the 100 million phone calls that we're getting in, or the 10 million pieces of correspondence. Fat lot of good, that language says. Some of this is not the IRS's fault. It's a matter of just needing the staffing. So there's an obligation there on Congress to fulfill that right. And then on the other hand, this cross-references with the right to a fair and just tax system. People say that's really nebulous. Oh, I think it's very specific if you look at my explanation. The explanation is that taxpayers have the right to expect the tax system to consider facts and circumstances that might affect their underlying liabilities, their ability to pay, or their ability to provide information timely. We have 41 million individual taxpayers who don't have broadband access in their homes. That I know from our surveys. So if the IRS is going on to online, putting more and more things online, and people are dealing with smartphones on a pay-as-you-go basis, searching 140,000 web pages on irs.gov, do you really think you have, one, the right to be informed and the right to quality service actually, met? I would say not. They're not looking at the taxpayer's specific facts and circumstances, even at a very macro level. They're not paying attention to the needs of taxpayers. And that's a violation, because it's law, of the right to a fair and just tax system. Okay, now just a reminder that we did recommend last year to codify the Taxpayer Bill of Rights as Section 1 of the Code and also codify the IRS mission statement and to include in the IRS mission statement protection of taxpayer rights, those words, protection, and we protect taxpayer rights, since it's now in the law. There was lots of discussion on the Hill about making it number 1 as a freestanding. Everybody, including Joint Committee on Taxation, just kept saying, floodgates, we'll have floodgates of litigation. And aside from Frank creating all those floodgates, my response is, so what? So what if we get litigation about this? I thought we were a common law country. I thought that's how we made law, was to have courts look at things and make rulings, and that became precedent, and then we learned something new based on right to fair and just tax system, the specific facts and circumstances of that taxpayer. That's what common law is about. So I don't have a problem with that. We dealt with that in CDP, that the first year, people coming into the courts, there were a lot of people who raised frivolous arguments. But out of that litigation, the courts determined that you didn't have to have a face-to-face hearing, a telephonic hearing would be okay. What was the standard of review? All sorts of things that defined what collection due process was. It was very meritorious in the opinions because they used those frivolous argument cases to define the procedure. Isn't that what we're supposed to do? Isn't that what the courts do? And I would also remind people that Flora was a judge-made rule. So it's been done before. What's wrong with that? Well, there's a lot wrong with Flora, and we're going to have a legislative recommendation this year about Flora, but the point is, it's a judge-made rule. All right, so the hard work ahead. I'll sort of fast forward to some things. IRM reviews. Taxpayer Advocate Service sees many, many IRMs, most IRMs, unfortunately, just because there's a volume of them, before they go public. It's one of the major occupations my systemic advocacy people have, is to try to stop problems from happening by looking at the IRMs and saying, you say that, we're going to have problems down the line. And what we have been trying to do is get taxpayer TBOR language into the IRMs, which are the instructions to employees. It can't be boilerplate, like just constantly saying, you've got the right to appeal, you can go to a LITC, things like that. The best example I've seen so far, although there are some others, was one dealing with pre-levy considerations by revenue officers. What we wrote there, so this is where the revenue officer is the collection person, is trying to decide whether to levy on somebody's bank account or their paycheck or something like that. The IRM now says, taxpayers have the right to a fair and just tax system. This means blah, 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 blah. It takes the language from the publication one, which means you have to look at their specific facts and circumstances. It's a direct quote. And then it says, therefore, in deciding whether to move forward with a levy, issue a levy, you should consider the following things. Now, what does that do? It starts with the general principle, you have the right to a fair and just tax system. It takes the agreed upon language about what that means, specific facts and circumstances, and then it says, this is how you exercise that. This is how you accomplish that. You look at the following things. It's a teaching IRM, and IRMs are public, and you all can tell the IRS you need to follow that. And we've written about this in my annual report so you can see the actual citation. But that's the kind of work we're trying to do with the IRMs. Now, some may say that the IRS can't do this kind of factual analysis for a taxpayer, that tax administration will grind to a halt. That's sort of like the floodgates argument. First of all, I have never seen tax administration grind to a halt, and I have been practicing since 1975, way too long. And so I would say to that, balderdash. I've been looking and waiting to use that word. So, after 18 years of watching this, what I have found is that the IRS's refusal to listen to the taxpayer and consider their individual facts and circumstances, that is what grinds things to a halt, because it creates rework downstream where you're using more expensive enforcement actions, and you're having to fight stuff in a much more expensive environment. Or you have a case in Taxpayer Advocate Service where two employees are working a case, my employee and the IRS employee, so that's double the cost. Or you're in litigation where you've got the court and the IRS, or you've got audit reconsideration, or you've got appeals, et cetera. So you have so many downstream costs because you didn't listen to the facts and circumstances in the first place. And I have demonstrated that in our reports over and over and over again. One of our studies, our research studies, we looked at fully conceded tax court cases involving the earned income tax credit. These are the lowest income, mostly unrepresented taxpayers, where the chief counsel agreed 100% that the taxpayer was entitled to the full amount of the EITC that they claimed on their return. And we looked at the administrative files. What happened in exam? Why did that taxpayer have to go to court? Most people say, oh, because they didn't raise it with exam. Well, I'm here to tell you that what we found was that on average, those taxpayers talked to exam 5 times. And there was one taxpayer who talked to exam 15 times. And they still didn't get to the right answer. They did not listen to the taxpayer. Whew. All right. Rights analysis, taxpayer rights analysis, some of the ongoing things that we're doing. We are looking at CDP notices. Collection due process notices are one of the most significant statutory taxpayer rights that taxpayers have. Similar to the notice of deficiency telling taxpayers you can go to the tax court before you have to pay the tax. Where in that note, in either one of those notices, do we bother to tell them that taxpayers have the right to appeal to an independent forum, or taxpayers have the right to privacy, which means that we will do something no more intrusive than necessary? There is a 1.4% response rate to CDP notices. All those floodgates, like we send out millions of notices and only 1.4% ask for the administrative CDP. So anybody wants to talk to me about floodgates, I just go 1.4%. And there's a few, much smaller percent of those CDP administrative hearings that actually end up in court. There are no floodgates of litigation. So to me, what we're going to work on is a CDP notice that is based in rights, so that and then we're going to test it so that we can compare the response rate to that notice as opposed to the IRS notice, and see whether we have actually been able to effectuate people's awareness of rights and why they should elect to do that procedure and what they are giving up if they don't elect it. Why is the IRS afraid to do that? Why do they not want to couch things in the words of rights? I don't know. All right. Now I'll just tell some little war stories. I know I'm running out of time. I'm hoping that that's okay if I keep going a little bit. I'm cutting into you a little bit, but tough. FBAR and Title 31 penalties. Financial crimes, FinCEN in Treasury, first of all, they delegated to the IRS certain penalties coming out of Title 31 rather than Title 26, so that IRS actually operates them. And FinCEN came and said, we want a different publication one for all these people who are violating our penalties. We'd like to eliminate the right to appeal. I was like, no. So they, first of all, the law says, the commissioner should ensure that IRS employees adhere to these rights, including the right to appeal. And if you've delegated this to IRS employees to administer, well, they're IRS employees, and so there's still a right to appeal. Now, what that right to appeal means in the context of a financial crime or a financial penalty under Title 31 may have a different meaning, just like you can't cry fire in a, blah, blah, blah. But that we can have a discussion about. But you can't have your own Pub 1. There's one Pub 1, period. Then there was the matter of civil forfeiture, which some of you may know about, where criminal investigation with other agencies were doing civil forfeiture of people's funds because of them making payments of over $10,000 or over, but they were structuring them so that they would be under $10,000 in cash, so they grabbed the money. And that was a big to-hoo, and Congress was very upset about it and held hearings and everything. And the Inspector General did an investigation, did a very good report on the IRS's procedures. And I sent a memo, which I don't think has ever been made public, although the Hill has it, so all you FOIA experts could think about that, to the Inspector General, doing a taxpayer rights analysis, a TBOR analysis of the IRS's approach, the criminal investigations approach to civil forfeitures. And the CI Council objected and said that TBOR doesn't apply to CI, to criminal investigation employees. Well, criminal investigation employees are IRS employees. 7803A does not say, Commissioner, ensure that the employees of the IRS, except criminal investigation employees, adhere to these protections. It says IRS employees, so it applies to IRS employees. I want to spend a moment talking about Keith's San Diego case, because I think it's a Pyrrhic victory. You've won the battle, but you've lost the war. I have spent 18 years trying to tell the IRS that there is no such thing as a voluntary levy. A levy is a distraint seizure action. You cannot volunteer to have a distraint seizure action. It's something that's done to you. So the IRS has been trying to do this very thing that they got to do in the San Diego case. I have spent my life trying to protect people's retirement savings. Congress agrees with me. They didn't create an exception to that 10% tax except in a levy situation. They have competing public policies here, that people not be poor in their retirement and become wards, were dependent on welfare and the state and public services, and then the collection of tax. And they've made their policy call on that. The IRS has ignored that policy call by now saying you can do voluntary levies. And the problem of that is that they have the power. Imagine somebody unrepresented and they have this little retirement account. Really, to levy on a retirement account, you have to go through all sorts of steps. But the IRS can say, ask for a levy and you'll avoid the 10% tax. Isn't that great? So by winning that San Diego case,
we have just harmed whole bunches of taxpayers. The other thing about that is there's a solution. Do an offer and compromise under effective tax administration authority, because there the IRS accounts for the tax, both the income tax and the 10% tax, that doing a withdrawal from your retirement account would create as part of the whole offer amount. They will deduct what you have to set aside to pay that tax from what you're offering. So there was a vehicle, and instead, we really created great harm to the taxpayer. So the last thing I really want to talk about, again, in the area of going forward, and I really hadn't thought about this until this morning when everybody was talking about the implied private right of action. There is one right that I think has that in it, and that is the right to challenge the IRS and be heard. When we did focus groups, this was the one right that every taxpayer and every preparer said, we love this right and we didn't know we had it. Well, that makes me nuts that they didn't know they could challenge the IRS. But the other half of that right, that you have the right, taxpayer, to challenge the IRS. That belongs to the taxpayer. But in this right, there's an obligation on the IRS, and be heard. You, IRS, have to listen to the taxpayer. That is core procedural due process. That, the taxpayer has the right to notice and the opportunity to object. So this and be heard imposes an affirmative obligation and duty on the IRS, a specific duty. And how many cases have we seen where the IRS has been told something and doesn't address it or listen to it or even respond? And, so to me, this is not just important in the collection due process area where you have to consider issues that are raised and things like that. It's important in accounts issues. It's important in identity theft. It's important in every single day of our lives, the work that the IRS does. So particularly in the routine things. And this is very important for low-income and unrepresented taxpayers. Now, again, I don't know what that means, but I do think that if we're talking about, implied, rights to action, that maybe you've got it in that right. So, sort of in conclusion, going forward in our taxpayer assistance orders, we're doing rights analyses. In our taxpayer advocate directives, we're doing rights analyses. In the annual report to Congress, we are identifying in our most serious problems, in our legislative recommendations, in our most litigated issues, these are the rights impacted by each and every single one of these proposals so that people can see how we're thinking about rights. And then we've made the recommendation not only that the National Taxpayer Advocate be able to comment, that the regs have to go through for a taxpayer rights analysis, just like the Small Business Chief Counsel for Advocacy under 7805F, but the other provision that the Small Business Chief Counsel for Advocacy has is the amicus brief authority. If there is a regulation that the Chief Counsel feels is not appropriate and it would harm small business, he can file an amicus brief. So much for the unitary executive theory. This is an executive branch employee filing an amicus brief against the government's position in court, or maybe for the government's position, who knows? I have asked for that authority so that I can file amicus briefs. I would have filed it in the San Diego case. Okay, never mind. And then finally this year, we are going in the annual report to Congress. The annual report to Congress, the theme of it this year is the taxpayer's journey. And we are going to start with the taxpayer's journey and map it out along with the rights that at each stage of the way are implicated. So it starts, in fact, with the right to be informed and disclosure of information and the way that the IRS is implementing the tax settlements, the tax and analyst settlement in terms of disclosure of opinions and things like that. We are also creating a real roadmap. It'll be folded up, it'll be a big piece of paper, and it'll be folded up into a little roadmap so that taxpayers can have a roadmap, and it'll say, you are here, and this is how you go. It'll be sort of like chutes and ladders, I thought. And and that will be a really great teaching tool for people to be able to see where they are. So with that, thank you.